We often forget that there are real people behind the changes to laws that impact all of us. And the truth is, many of the employees who bring about the changes to those laws that impact all of us have a very compelling story, series of events that lead them to do it. Today, we're going to talk about those employees who fought for the changes made to severance agreements. And I'm going to share a little bit about my story with severance agreements as well. So stay tuned. Hi, I'm Harlow Reed. Welcome to the HR Insider. Leaving an employer can change people's lives in so many ways. Sometimes it's expected, other times it's unexpected. As an HR professional, I have always looked at separations from employers in two broad categories. The first one is a person, an employee decides that they want to move themselves out of an organization. They put themselves on a new path. They're going to own that decision, and that is something they're choosing to do for whatever reason, or the author and finisher of us all puts us on a different path. And today we're talking about the McLean Macomb case, which is an example of employees who were forced to move on unexpectedly and how that decision led to permanent changes to the manner in which all employees leave an organization. Let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. Thank you so much for liking this video, making a comment, and subscribing to this channel. The story begins at Mount Clemens Regional Medical Center in Michigan, which operates under the name McLaren Macomb. McLaren Macomb is really its assumed name that was changed to McLaren Macomb after they joined the Michigan Healthcare Network, which is the largest healthcare system in Michigan. Now, the hospital was located in Mount Clemens, Michigan, and it employed about 2,300 employees. But after the onset of the coronavirus pandemic in March of 2020, of course, the pandemic happened before that, but in March of 2020, the government issued regulations that prohibited the hospital from performing elective and outpatient procedures and from allowing non essential employees to work inside the hospital. So I remember as an HR professional who was actively working and also participating in layoffs during that time, I can tell you it was some of the worst of times. And I don't know where you were or what you were doing, but the mental health of so many people impacted by layoffs and changes brought about just in general as a result of the pandemic has not been the same since. At least that's been my experience as an HR leader. I would love to hear what your experience has been since the pandemic, and if you can reflect on how life was before the pandemic and after the pandemic, because I definitely know and see and feel and sense a change. So would love to hear your comments about that. But anyway, so there were 11 employees that this hospital decided that they were going to terminate as a result of these prohibitions that were placed on them by the government. And all 11 of these employees were nurses. So they terminated them. And what was so crazy to me when I was reading through this case is that they terminated people who were nurses during the middle of the pandemic. And I just can't imagine, because if you think back to the pandemic, everything that was happening, they needed nurses, they needed medical workers. How are you terminating them? But who knows? Maybe they terminated them and put them somewhere else in the hospital. At least that's what I hope happened. But yes, that's what happened. And so these 11 employees were offered a severance agreement, and they were asked to sign. They were offered severance and asked to sign severance agreements. And the language in the agreement prohibited them from making statements that could disparage or harm the image of the hospital. And it also prohibited them from disclosing the terms of the agreement that they made with the hospital. So they offered severance to the 11 employees who were RNs that were terminated, and the employees signed these severance agreements. But there was a twist because the employees were all members of a collective bargaining unit, which means their employment conditions, including their separations, are governed by the National Labor Relations Board, or the NLRB. And let me just say, as an HR leader, I've never worked in a union environment. Although when I was in law school, I studied unionized organizations and the administration of those environments. I've never had the experience of working with a union, and I have to say, I am okay with that. But the NLRB challenged the legality of the agreement signed by these 11 nurses because they felt that they violated the employees' rights under Section 7 of the NLRA. Section 7 of the NLRA protects employees' rights to engage what is described as concerted activity. And basically, that is the right for employees to talk about how they can improve their environment, how they can influence change on the conditions of things like pay or work conditions, things to protect them. If you have ever been a part of a union environment, you know that the workplace comes with extensive regulations, layers of bureaucracy that HR leaders have to sort through to reach an expected end. I mentioned that this was all happening during the middle of the pandemic. And the challenges that were coming, that we were facing during that time, were overwhelming. They were unique and definitely unprecedented in so many ways. And it was during this time that the HR staff who executed these agreements were expected to give the union notice. They were required to do this. They were required to give the union notice that they were permanently terminating 11 employees, and they didn't do that. They also did not give the union leaders an opportunity to bargain regarding that decision to terminate those employees. And they did it without regard to the impact on those 11 employees whose jobs would be lost. They also did not give the union copies of the severance agreements before they were presented to the employees. And also, they didn't include the union in their discussions. So there was no union steward available as those discussions were taking place with the employees regarding their termination or their severance agreement. So the HR staff really bypassed and excluded the union from this very big workplace event of a permanent job loss. And this is the part of HR that if you are in a union environment, you have to remember and be familiar with what the terms are of the union. Some of those terms are going to be standard, but some of those terms are going to be unique. So it's clear that the HR department either wasn't familiar with it or because they were in a pandemic and the times were so difficult to manage that they pushed through with these and executed on these terminations without following the terms of the union arrangement that they had with these employees. So in February 2023, the NLRB ruled that the hospital severance agreements were unlawful. And they were unlawful specifically because the non disclosure and non disparagement provisions um, interfered with the employee's rights to discuss workplace issues. And they required that employers cannot offer severance agreements that require employees to waive their rights under Section 7, where they are allowed to discuss workplace conditions, criticize their employer, or speak out about potential violations of labor laws. And this clarified that these protections apply to both union environments and non union environments. So, this was the workplace termination that redirected us all, not just the 11 employees that were impacted by the layoff at the hospital in Michigan. And if you are administering layoffs or someone you know is laid off in 2025, I encourage you to watch my video on severance agreements that talks about if severance agreements are legal and things that you need to consider to ensure that the language in the agreement that you are about to sign or that you are about to administer to an employee is in compliance with the NLRB ruling. Thanks for watching today's episode of the HR Insider. If you found this video helpful, please be sure to like, subscribe, and hit the bell icon so you don't miss future updates. And remember, workplace fairness starts with accountability. I'll see you in the next video.